In this, my first opening of the legal year as Chief Justice, I would like to outline 3 fundamentals of the judiciary that we are committed to. First, the judiciary must be and must remain an independent and impartial judiciary. In Hong Kong, judicial independence is both mandated and guaranteed under the Basic Law. The judicial power, including that of final adjudication, enjoyed by the Hong Kong Special Administrative Region under the Basic Law, is exercised by the judiciary independently, free from any interference, as Articles 2, 19, and 85 of the Basic Law provide. An independent judiciary is essential to the rule of law and the due administration of justice. It is equally crucial to public and business confidence, whether local or overseas, in our judicial system, as well as to the international reputation of Hong Kong as a society that is governed by the rule of law under the one country, two systems arrangement. Amongst other things, judicial independence means the judiciary, the courts, the judges, and judicial officers, whom I shall refer to collectively as judges, when discharging their judicial functions, must not be subject to improper extraneous pressure or influence. The Basic Law and the relevant legislation provide clear and strict provisions regarding the appointment and removal of judges. In particular, Article 88 of the Basic Law provides that judges are appointed by the Chief Executive on the recommendation of the Independent Judicial Officers Recommendation Commission, which is chaired by the Chief Justice. Appointment of judges, whether local or from overseas, must be based on, and only based on, judicial and professional qualities, as stipulated under Article 92. Judicial appointments must be free from political or other irrelevant considerations. The second fundamental of the judiciary, which overlaps to some extent with the first one I have just outlined, is that the judiciary must comprise judges who are upright and who are prepared to uphold rights. A judiciary can only be as good as the judges that mends its cause. The judicial oath is a requirement under Article 104 of the Basic Law. It requires every judge to uphold the Basic Law, to bear allegiance to the Hong Kong Special Administrative Region, to serve Hong Kong conscientiously, dutifully, in full accordance with the law and with integrity, to safeguard the law and administer justice without fear or favor, self-interest or deceit. It can only be fulfilled by judges who are upright, judges who are persons of integrity. It is worth repeating that judges must be impartial, free from bias or prejudice. Judges must be fearless and be prepared to make decisions in accordance with the law, regardless of whether the outcomes are popular or unpopular, or whether the outcomes would render themselves popular or unpopular. A judge must be honest and intellectually honest. Binding laws and precedents must be dispassionately applied and applicable rules and procedures faithfully observed, even if this means getting a result the judge personally might not prefer. Powers and discretions must be exercised judicially. Judgments must set out the true and entire reasons for the decisions made. The third fundamental of the judiciary that I would like to discuss is that our judiciary must remain a professional and efficient judiciary that moves with the times. A modern judiciary must be an efficient judiciary. The annual number of leave applications for judicial review relating to non-refoulement cases has risen from 60 in 2016 to over 3,700 in 2019, even though the number of leave applications in other types of judicial review cases has remained stable at around 160 per year. The resulting stress on our judicial capacity is tremendous, and it is not helped by the outbreak of the COVID-19 pandemic last year, which seriously disrupted court operations, nor the large number of criminal cases arising from the social events in 2019. Whilst we will continue to deal with these workloads with determination and perseverance, specific attention will be given to the prioritization of different types of cases so that backlogs and bottlenecks can be tackled more strategically and effectively. In particular, steps to enhance the practice and procedure of the constitutional and administrative law list in the High Court will be taken, and important public law cases and appeals will be given priority and fast-tracked for hearing so as to reduce the delays and the social costs that these litigations involve.